Lady Volaw Trust Appeals.
My Lady, my Lords, I appear for the appellants in this matter with Advocate Coy of the Jersey Bar and Mr. Hugo Leaf of the English Bar. Respondents are represented by the Attorney General of Jersey, Mr. Robert McCrae QC, and with him, Advocate Sharp QC. My Lady, my Lords, with the usual apologies, there are a couple of extra items that have found their way onto your desks. You'll find the final volume of authorities, volume 16, which is now available, but will only be available in hard copy. There's also a note which sets out a summary of the Strasbourg jurisprudence in chronological order, which I will be taking you to during the course of the hearing. Given the sheer number of those authorities, some of those I'm not going to be able to take you to, and so I'll simply refer to the provisions or the paragraphs in the case for your Lordships and your Ladyship to read at a later time. My Lords, as far as the two applications before you are concerned, there's an application by the respondents to admit fresh evidence. We've indicated we're happy for the board to consider that de bene esse and say no more about that at this stage. As far as our supplementary case is concerned, it's our position that that will in fact shorten the proceedings, and hope that there's nothing more that needs to be said about that. By way of introduction, my Lady, my Lords, Volaw is a trust and corporate services firm established in Jersey and regulated by the Jersey Financial Services Commission under the Financial Services Jersey Law 1998. It provided trust and corporate services to Mr. Berg Larsen, a Norwegian businessman, and a number of companies with which he's associated, including the 9 appellant companies, including by the provision of directors for those companies. Although this case concerns the privilege against self-incrimination, Volaw and the other appellants wish to make it clear that in their view they have committed no wrongdoing under the laws of either Jersey or Norway. The original compulsory demands for information which form the basis of these appeals, that's to say the Tax Information Exchange Act notices, which I'll call the TIA notices, and the 1991 fraud law notice, which I'll call the 1991 law notice, were made in the context and following the conviction of Mr. Larsen in the Bergen Criminal Court in Norway. His conviction has since been overturned, and as a consequence, the Norwegian authorities, both the tax authorities and the prosecuting authorities, no longer seek any of the information that forms the basis of those notices. And as a consequence, the respondents have withdrawn the TIA notices, and as far as that appeal is concerned, with your Lordship's leave, we will develop the appeal. We're agreed that it raises issues that do require to be resolved, and we respectfully submit that it's neither academic, but if it is, then that you should consider it on ordinary Salem principles. As far as the 1991 law notice is concerned, the original request that precipitated that notice was to assist Mr. Larsen in his appeal in Norway. And now that his appeal has succeeded, the Norwegian DPP has withdrawn his request for mutual assistance for the purposes of obtaining those documents. However, unusually, the Attorney General has now switched horses and asserts that this notice is now being pursued for the purposes of a criminal investigation in Jersey. Now, the highly unusual circumstances in which he maintains that notice are set out at paragraphs 54 to 63 of the SFI and at paragraph 148 of our case. There's been no amended notice, so Mr. Larsen remains the person under investigation. It's not clear who are the suspects or why. However, in light of the stance the Attorney General has taken, the issues remain live on the second appeal. My Lords, my Lady, both the TIA notices and the 1991 law notice require the appellants, their directors and officers, on pain of serious criminal sanction, to provide potentially self-incriminating documents to the Jersey and Norwegian authorities purposes, among others, of a criminal investigation into the appellants and including its directors or other officers.
I think it would be helpful for us to have a look at the notices and legislation under which they were issued.
Well, I was going to take my lords and my lady to the legislation, and I'll take you to the notices themselves. If I just set out the outline of how I was going to approach the appeal, my lord, with your lordship's leave,
yes.
And then I'll take you briefly to the key documents before then turning to the legislation. But the approach that I propose to take, given that time is a precious commodity before the board, is to take the facts as set out in the SFI as read, and also the arguments as set out in our case and our supplementary case as read. I will take your lordships to the key documents as requested, then to the key statutory provisions, and then I propose to develop the submissions under the first issue and concentrating my fire on the Article 6 position, and less time will be spent on the common law position. And I anticipate that I will not have time to develop any of the other issues, and therefore they will need to be taken as read in our case. My lords, the key documents can be found in the record, and if we start with the tier notices, they begin with the requests for information from the Norwegian tax authorities. They are in volume 3 of the record, page 813 of volume 3.
Page 813?
813, my lord. That's electronic bundle, page 813. And you'll see that the covering page at 813 is an exhibit page, because the requests were in the event exhibited to an affidavit by the Deputy Comptroller, Mr. Cousins, in April 2015, some months after the notices were originally served. And so it wasn't apparent to the appellants at the time the notices were served, which I'll take you to in a moment, that in fact these included requests for the purposes of a criminal investigation. Behind that page is the first of the requests. There are 9 requests in total. The one at page 814 is for North East Oil Limited. And if I just highlight a couple of points, if you look at the bottom of page 814, under point 7, urgent reply required due to, and then checked is suspected fraud. Over the page, on page 815, we see the identity of the person under examination, North East Oil Limited, care of Volaw Group at the top, as well as Mr. Berg-Gert Larsen. The information requested at paragraph 10, all documents and records that Volaw Trust Services Limited holds, which relate to Berg Larsen, all documents that it holds regarding the company identified in section 8, so that's North East Oil in this case, and all documents that Volaw holds relating to any trust held through the persons or companies identified in section 8.1. And the dates from which they want the documents are from the 1st of January 1998. Now, as I've indicated, there are 9 notices, or 9 requests in total. These are the requests that were made under the international agreement, the Tax Information Exchange Act agreement between Jersey and Norway. Some of the requests seek information going back as far as 1982. And the total amount of documentation that Volaw in the end had to gather together pursuant to this amounted to over 6,000 documents and over 150,000 pages. Over the page, on page 816, the top of the page, second paragraph, for the avoidance of doubt, we request confirmation that all the documentation may be used in relation to both Berg Larsen and the companies identified in section 8 above. And then at 12, further down the page, the tax purpose for which the information is requested, determination, assessment and collection of taxes is checked, but also investigation or prosecution of criminal tax matters. And then, my lords, if you look at page 817, at the bottom of the page, under the narrative, if I could just direct your attention to the last but one paragraph on that page, which begins, if a company is resident in Norway and it received taxable income which it fails to report, this may amount to a criminal offence on the part of the company in the form of tax evasion and section 12(1) of the Tax Assessment Act, and aggravated tax evasion. It may also amount to criminal offence by the directors and or those otherwise controlling the company and or other persons involved in the company. And then over the page, top of the page, second line, pursuant to section 12(1)(1)(d) of the Act, failure to submit a tax return may amount to a criminal offence on the part of the chairman of the board and the board of directors. And then this paragraph, the finding in Bergen District Court's judgment in relation to Norden arose in the context of the prosecution of Mr. Larsen, not of the company. It's thereby not a binding decision in relation to Norden. However, it may be of substantial probative value and lends weight to our investigations into Norden and our further investigations into Mr. Larsen. We need access to the Jersey documents in order to clarify whether Norden are resident in Norway and the amount of any undeclared taxable income in Norway. We also need access to the Jersey documents in order to clarify who actually controlled the company. In the following, we provide more details about the state of our knowledge. And then over the page, on page 819, we appreciate that this request, in effect, reiterates part of the request of 26th of February 2010, insofar as it seeks information in relation to Mr. Larsen and Norden. However, we are aware of the fact that the Royal Court and the Court of Appeal of Jersey ordered that the information to be received pursuant to that request may only be used by the Norwegian Tax Authority in relation to Mr. Larsen's personal tax affairs. The information now sought is obviously linked to Mr. Larsen, but our inquiries have broadened, and we also wish to be able to use any information that may now be obtained in relation to each of the persons under investigation into sections 8.1 and 2, without in any way breaching the orders of the Jersey courts. So, my lord, my lady, when the Jersey courts considered the lawfulness of the earlier tier notices, which are set out in the SFI, they had dismissed a claim for judicial review against those, but had made a specific condition that the information could only be transmitted to Norway on condition that it be used for tax purposes, not for a criminal investigation, and relating only to Mr. Larsen. So what the Norwegian tax authorities wanted to do was to broaden their investigation, and now it was a criminal investigation. And my lords, in relation to all of these requests, they relate to companies for whom Volaw provided corporate services. Therefore, Volaw and its directors were potentially liable as a matter of Norwegian law in respect of those offences that were being investigated. And indeed, the Commissioner, Mr. Belloff QC, accepted in the Royal Court that Volaw were charged with a criminal offence for the purposes of Article 6 by virtue of the fact that the Norwegian tax authorities were seeking this information for the purposes of a tax investigation. The next document, my lords, I won't take you to any more of the requests. There's 9 of them. They're in very similar form. But the notices themselves can be found in volume 2 of the record, at page 409. This is a covering letter from Andrew Cousins, the Deputy Comptroller of Taxes, to the Secretary of Volaw Trust. Second paragraph, under the provisions of Regulation 3 of the tier regulations, I'm authorised to require you to provide tax information which is either within your knowledge or belief or which you have in your possession, custody and control. And then over the page, there are 9 tier notices that correspond with the 9 requests that were made by the Norwegian tax authorities. However, none of the notices identify the fact that the information is being sought for the purposes of a criminal investigation. Simply records a request, well, a demand, a requirement at paragraph 3 on page 410. I require you to provide within 30 days the following tax information that I require for that purpose from the 1st of January 1998 to the present. So same date as we saw on the request, which was for the same company, North East Oil, and the same documents that were contained, that were sought in the request. And then over the page, halfway down, for the avoidance of doubt, reference to tax information in this notice may be information within an individual's knowledge or belief, or information recorded in a document or any other record. And then the next paragraph down, under Regulation 14, any application for judicial review must be made no later than 14 days after this notice is given. Despite any application for judicial review being made, the information requested in this notice must be provided within the time limits specified. And then this, a person who intentionally and without reasonable excuse fails to comply with these requirements is guilty of an offence under Regulation 15 and or Regulation 16. Now, my lords, my lady, Volaw, through their lawyers, asked for a copy of the request that lay behind the notices. In the meantime, a claim for judicial review was brought by Mr. Larson and by Volaw, but at that stage the privilege had not been raised because it wasn't possible to know that there was a criminal investigation. That didn't become clear. The application for judicial review was made on the 7th of November 2014, but it wasn't until an affidavit by the Deputy Comptroller, Mr. Lequero, in April 2015 that it became apparent that there was a criminal investigation. And that's volume 3, page 800, at paragraph 8. I'll just read it, my lords, it's not necessary to go to it. The authority wishes to obtain the evidence so as to investigate whether criminal offences have been committed by the relevant companies and or Mr. Larson and other associated persons. An application was then made to Commissioner Belloff for disclosure of the requests. That application was unsuccessful. However, the Comptroller then agreed to disclose the request by consent. So there was no need to press the matter any further with the Commissioner or to appeal his decision. And you've seen already the exhibit sheet by which the requests were exhibited by the Deputy Comptroller in April 2015. And following disclosure of those notices, the appellants amended the grounds to plead that this breached their privilege against self-incrimination. My lords, my lady, that's the evidential background, I think, that's relevant for the tier notices, for now anyway. The 1991 law notice, that can be found in volume 1 of the record, at page 107. Lords, as I explained, Mr. Larson, having been convicted, appealed to the Norwegian Court of Appeal. And in the course of those proceedings, a request was made by the Norwegian prosecuting authorities to the Jersey Attorney General for assistance, for mutual assistance, to provide documents that Mr. Larson wanted for the purposes of his appeal. And in the light of that request, the Attorney General, through his assistant legal advisor, Ms. Cornu, issued a notice under the 1991 law notice, and we see the covering letter on page 107, and then over the page we can see the notice itself, a supplementary notice to answer questions, furnish information and produce documents, person under investigation, Berg Larson, and it requires, it sets out the paragraph 3, her reason to believe you have relevant information about the affairs of the person under investigation, and that I therefore require you to answer questions and otherwise furnish information with respect to matters relevant to the investigation to myself. And paragraph 4, I also require you to produce within 21 days true copies of the following documents. And they're then set out at page 109. My lords, my lady, the documents substantially cover those that were sought under the original tier notices. Not entirely, but included many of those that had been sought under the tier notice. Now, my lords, my lady, the practice of the Attorney General, his policy, when a request for mutual assistance is made, is he either makes a request under the 1991 law, fraud law, or he makes a request under the Criminal Justice International Cooperation law. But in either event, he requests the authority that's making the request to provide an undertaking. And my lords, I will take you to the guidelines in a moment, but in this case, an undertaking was sought from the DPP that he would not use the information for the purposes of an investigation, a criminal investigation, into Volaw and or its directors or other officers, or the appellant companies. And his response is at page 407 of volume 1 of the record. Just to summarise, he refused to give any undertaking to that effect. What I'm going to be calling, my lord, my lady, a use immunity. So he was requested to give a use immunity in relation to the documents sought, and he refused, saying that without knowing the contents of these documents, the prosecuting authority cannot, under such circumstances, endorse a statement specifying that the information collected and confiscated cannot be used to prosecute those responsible for unlawful acts. My lords, of course, since then, the notice that the original request has been withdrawn, and now where we are is that the Attorney General has, notwithstanding the withdrawal of the request from the Norwegian authorities, decided to maintain the 1991 law notice, which he did by way of an email on the 26th of January. My lords, if you have the SFI to hand, it's paragraph 62. And this sets out the events that have happened since the hearings in the Court of Appeal. I won't take you to the judgments, assuming that my lords, my lady have identified where those are, unless requested. But the events that have happened since those judgments, paragraph 61, the Norwegian Court of Appeal allowed Mr. Larsen's appeal on the 30th of August 2016. On the 29th of September 2016, the Attorney General was notified the Norwegian prosecutor no longer had a need for the documents sought under the 1991 law notice. The appellants requested the notice be withdrawn and were informed by an email from counsel for the Attorney General on the 26th of January 2017 that the Attorney General has determined to open his own investigation into the case and therefore maintains the 1991 law notice in order to progress his inquiry. Now, my lady, my lords, there have been no further communications from the Attorney General setting out on what basis he maintains the 1991 law notice. The notice has not been amended, so it still states that the person under investigation is Mr. Larsen. And in those circumstances, it's very difficult for the appellants to know who the suspects are, what they are suspected of. But the Attorney General has indicated that for the purposes of this appeal, the appellants are all suspects of criminal offending that amounts to serious fraud, but has given no further detail than that. But there it is. That is why the issue is live and why it is before your lordships, notwithstanding the developments since the last hearing in the Court of Appeal. So, my Lords, I hope that covers briefly the factual background to these appeals. Can I...
And the appellants, apart from Volaw itself, are, is it six other companies?
There are 6 other companies on the 1991 law notice and 9 other companies on the tier notices appeal.
Right. I see.
And their directors and officers. Could I ask you to take up volume 1 of the authorities bundle, and I'll outline the relevant statutory provisions. So the investigation of fraud law, or the investigation of fraud Jersey law 1991 begins, it's at tab 2 of volume 1, at page 1590. And section Article 2 begins on page 1594. As I'll explain in a moment, my lady, my lords, this is in almost identical terms to the Criminal Justice Act 1987, which sets out the powers of the Director of the Serious Fraud Office. So the Attorney General's powers under this Act, subparagraph 1, shall be exercisable in any case in which it appears to the Attorney General that there's a suspected offence involving serious or complex fraud wherever committed, and there is good reason to do so for the purposes of investigating the affairs or any aspect of the affairs of any person. By subparagraph 2, he can issue a notice to the person under investigation, and by subparagraph 3 over the page, he may issue a notice in writing requiring a third party to produce, among other things, specified documents. And that is the power that's been exercised in this case. My Lords, subparagraph 4, if on an application by the Attorney General, the bailiff is satisfied in relation to any documents that there are reasonable grounds for believing, A, 1, that a person has failed to comply with an obligation under the article to produce them, then the bailiff may issue a warrant, as is mentioned in paragraph 5, and that's a warrant for search and seizure. And, my Lords, just to put a marker down, it's our case that if a person has a reasonable excuse for not complying with a third-party notice on the grounds that to do so would constitute a breach of the privilege against self-incrimination, then they are not acting contrary to an obligation imposed by subparagraph 3, and therefore the bailiff would not have any power to issue a search warrant. One of the points that the respondent is making, but I just flag that up now. It's our case that there would not be power to issue a warrant in circumstances such as those where the appellants, if we're right that they're entitled to raise the privilege, have done so properly. Subparagraph 7 at the bottom of that page constitutes a limited use immunity in relation to statements only. So it doesn't include documents. It is in identical terms to subsection 8 of section 2 of the Criminal Justice Act 1987, which provided a similarly limited use immunity in relation to statements. And in the House of Lords case of Ex parte Smith, Queen against the Serious Fraud Office Ex parte Smith, the House of Lords held that section 2 of the 1987 Act impliedly ousted the common law privilege in relation to documents. So we accept, for the purposes of this appeal, that section subparagraph 7 of Article 2 of the 1991 law has exactly the same effect. But of course that doesn't affect the position under Article 6. Subparagraph 13, any person who without reasonable excuse fails to comply with the requirement imposed on the person under this article shall be guilty of an offence and liable on conviction to imprisonment for a term not exceeding 6 months or to a fine or to both. Just pointing out, there's a defence of reasonable excuse. I've I've already made the submission that the PSI would be a reasonable excuse. But there, my lords, are the necessary ingredients for the privilege to be engaged. An investigation, a criminal investigation, with information being sought under pain of criminal sanction in the context of a criminal investigation. And while the use immunity in relation to statements prevents any information being obtained being used in a criminal trial against the individual insofar as it constitutes statements made, at common law, any privilege in relation to documents is ousted. My lords, that is why we don't run any common law arguments under the 1991 law notice appeal. Those arguments only run under the tier notices appeal, and I'll come to that in just a moment. But the other provision to draw to your Lordship's attention in relation to the 1991 law notice are the mutual legal assistance guidelines that I mentioned, because, of course, in this case, the 91 law notice was originally issued at the request of the Norwegian DPP. You'll find that in Volume 1 at tab 5.
Can I ask you, just before we go to that, about the effect of Article 2.7b? If the statement can only be used where in giving evidence a person has made an inconsistent statement, does that carry any implication under the law of evidence in Jersey that the statement is only admissible as going to credibility?
Well, I'm very grateful for drawing that out, because this is a point I was just going to come to.
Oh, right, okay. Well, let me take you out of
while we're here, it makes sense for me to make the point. My lords, when I take you to the Criminal Justice Act 1987, you will see a provision in that Act, subsection 8AA, which was introduced after Saunders by the Youth Justice and Criminal Evidence Act in order to bring the 1987 Act into compliance with Article 6. And it states in terms that any statement that is made can only be used if it's introduced by the defendant themselves. So it can't be used by the prosecution unless the defendant has himself brought it in. That safeguard does not exist under the 1991 law. So as matters stand, the law in Jersey is the same as it is in the law in Jersey now is the same as it was in Northern Ireland when the Strasbourg court considered a case called Shannon against the United Kingdom. And in Shannon, the Strasbourg court held that a provision like subparagraph 7 of Article 2 provided insufficient protection for the privilege under Article 6. So although we're concerned with documents and not statements, it is a fact that the 1991 law is at the moment incompatible with Article 6 because it doesn't include a provision akin to that introduced in the 1987 Act. I'm not sure if I answered Your Lordship's question.
Thank you.
I was going to show Your Lordship the mutual assistance guidelines, and then I'll just show you the relevant provisions of the 1987 law. So the mutual legal assistance guidelines at tab 5. They're guidelines which explain to a requesting authority what it is that they will need to include with any request. And if you turn over the page to page 1635 under the heading, what information should the request contain? Requests in general, all requests seeking evidence in relation to a criminal investigation, prosecution or confiscation should please contain the following information. And then the only one that I'd like to draw to Your Lordship's attention over the page at the top, 1636, a signed undertaking in the form set out at Annex A. And then Annex A contains an undertaking that the requesting authority must sign, confirming that any information and documents obtained will only be used for the purposes of that investigation and any prosecution arising out of that investigation and any connected criminal confiscation proceedings. Now, my lords, there was a question mark about whether, for the purposes of that investigation, the information could be used by the Norwegian authorities to prosecute Volaw and all the appellant companies, because, of course, by this stage they already knew they were suspects in criminal offences committed in Norway. And so a request was made for a clearer undertaking that would have provided a use immunity for Volaw and the appellant companies in Norway. And I've shown you the letter from the Norwegian authorities which refused to give that use immunity. I should also point out that notwithstanding the refusal of the Norwegian authorities, by the Norwegian authorities to give a use immunity, the Attorney General nevertheless continued with the 1991 law notice, even though no undertaking had been given. But of course, that factual matrix has now fallen away now that the Norwegians have withdrawn the application. My lords, can I take you to the statutory background to the TIA notices now? Sorry, I was going to take you to the Criminal Justice Act first. I'm sorry, my lord. So that's volume 5 of the authorities. Tab 42. And it's page 2982 I'd like to draw to your lordship's attention. We'll see at subsection 8 of the 1987 Act, subsection 2.8, at the top of page 2982, is in identical terms materially to Article 2.7 of the 1991 law. But then there's this additional provision, subsection 8AA, which makes clear that the statement cannot be used unless the defendant himself introduces the evidence to which it relates. And it's that safeguard that was introduced after Saunders. It was that provision which was found to be wanting in Shannon, and the absence of that provision means that the 1991 law notice is, in any event, incompatible with Article 6. But it doesn't apply on these facts. However, my lords, the other point to make is this. Subsection 8AA was introduced after Saunders by the Youth Justice Criminal Evidence Act 1999, along with a number of other provisions, to amend the investigating powers, a number of investigating powers, so as to bring them into compliance with the Convention. And they were introduced on the understanding that the decision in Saunders only required a use immunity in relation to statements. That's a point I'll come back to, my lords, but it runs like this. If we're right, and all those statutory provisions that were amended, and they include the 1987 Act, but they also include, for example, Section 434 of the Companies Act, Section 286 of the Insolvency Act. If we're right that those provisions were introduced on the basis of an erroneous understanding of Saunders as only applying to statements, and in fact, Saunders properly read applies to documents as well, then we submit that you should not give the weight you would otherwise give to those provisions as evincing a parliamentary intention to only remove the privilege in relation to documents, because, as I said, it was made on the basis of an erroneous understanding of Saunders. Of course, I've got to demonstrate that it is an erroneous understanding, and that's where I'm going to be focusing most of my submissions. The last point to make in relation to the 1991 law is this. I've mentioned Article 2 for the power of the bailiff to issue a warrant. The same power, my lords, my lady, appears in the 1987 Act at Section 2, subsection 4, and can be exercised in the same circumstances. The other reason why we respectfully submit that no search warrant would be obtainable in the circumstances of this case is because in the case of Rawlinson and Hunter, the Divisional Court gave very important guidance on the exercise of the power under Section 2.4 and emphasising the limited circumstances in which that power could be exercised and the safeguards that were necessary in order for it to be exercised lawfully. Rawlinson and Hunter, I won't take you to it, but it's volume 14, tab 150, page 6771, and it's paragraphs 78 and paragraphs 80 to 89. And for reasons we develop in our supplementary case, at paragraphs 28 and onwards, the board cannot assume that the respondent would be entitled to obtain a search warrant in default of compliance with the 1991 law notice if the Article 6 privilege is engaged.
Can I just be clear, so far as you say that the absence of a subsection 8AA equivalent from the 1991 law invalidates the notices, the notice under the 1991 law. I'm not sure I follow your point. The 8AA is concerned with statements.
Yes. It doesn't apply on the facts of this case.
No, that's the point I was...
Yes.
Right.
I'm not relying on it.
Right.
My submission is, look, they're going to have to amend the 1991 law notice, the 1991 law anyway, because it was never amended in the way that the 1987 Act was. So in that respect, it is incompatible. But we obviously have to go further than that and demonstrate that the limit imposed by Article 2.7 of the use immunity to statements and not including documents is incompatible with Article 6.
Your central argument is right. The lack of an amendment in terms of Section 2.8AA is essentially incidental, isn't it?
It is incidental, my lord. I accept that. The tier notices, my lords. We'll start with the taxation implementation Jersey law, which is at volume 1, tab 3. And if I can ask you to turn to page 1602, which provides that the states may by regulations make such provision as appears to them to be necessary or expedient for the purposes of implementing an approved agreement or approved obligation and dealing with matters arising out of or related to such an agreement or obligation. So, my lords, this empowers the states by regulations, that's to say, not by primary legislation but by secondary legislation, to introduce regulations to give effect to tier notices, so tier agreements with other jurisdictions. The point to make before we move away from this provision is that it empowers the states by regulations rather than by primary legislation to do that which is necessary or expedient. And it's our submission on the fifth issue that a power to do that which is necessary and expedient does not confer sufficient vires to remove fundamental common law rights, applying the approach of the Supreme Court in Ahmed. Difference between regulations and primary legislation in Jersey is somewhat different, I accept, from that which obtains here, because the states themselves pass regulations The difference between them is that primary legislation must be consented to by the sovereign, and therefore must be approved by the Privy Council. And our submission is that a piece of secondary legislation, even if it's passed by the states, which does not have it provides for the removal of a common law right, cannot remove a common law right if the parent legislation does not empower it. And the parent legislation doesn't empower it because to do that which is necessary or expedient is not sufficient to remove common law rights, unless that follows by necessary implication. And I'll have to explain why that doesn't follow by necessary implication in due course. The tier notices, the tier regulations are at tab 4. These are made under the 2004 law.
Sorry, which page?
Page 1604, my lord. 1604. Tab 4. These are the tier regulations as amended, which include the amendments which were challenged by Mr. Larson in the parallel judicial review proceedings. And the judicial review challenged, among other things, the fact that a right of appeal to the Court of Appeal was removed, so that there was only a right of appeal to the Privy Council. But we're not concerned with those matters here. So these are the regulations as they were in force at the time that the tier notices were issued. And if I could ask you to first turn to paragraph 1A on page 1608, which defines tax information, which includes 1D, information that's foreseeably relevant to the investigation or prosecution of tax matters. Regulation 2 provides for a power to obtain information from the taxpayer themselves. Regulation 3 provides the power to obtain information from third parties, and that is the power that was exercised in this case. My Lords, in relation to that power, there is a use immunity in place that one finds at Regulation 10A on page 1610. This is a use immunity that only applies to answers given or statements made. It doesn't apply to documents. On its face, and one gets there because at 10A2, the regulations provide that the answers given or a statement or deposition made by an individual in compliance with the notice given under Regulation 2 or 3 may not be used in evidence against the individual in any criminal proceedings except proceedings under Regulation 5.2. But the protection, it can be seen, is in relation to answers given or a statement or deposition made. 10B sets out the manner of provision of tax information, and 10B1 provides that tax information within an individual's knowledge or belief is provided by way of answering questions or by making a statement or deposition. So that is the answer or statement to which the use immunity in 10A2 applies. 10B3, tax information recorded in a document or any other record is to be provided by way of a copy of the document. And on its face, we accept that 10A2 doesn't include documents, and therefore on an orthodox interpretation, if there is virus in the regulations to oust the common law privilege against incrimination in relation to documents, then this does so. We accept that. We didn't accept it below, but we accept it here. However, we submit that the parent power under Section 2 of the 2004 law does not authorise the making of regulations that remove the privilege against self-incrimination in relation to documents, because it's neither necessary or expedient to do so for the purposes of giving effect to the agreement. And in this case, it's the Jersey-Norway Tax Information Exchange Agreement, which I'll take your lordships to in just a moment.
Can I ask you in relation, if we go back for a moment to the 2004 law, and you took us to Article 2, on page 1603, I'm wondering what you would say about Article 4. Now, I'm looking at particularly the words in the second line, or otherwise. So effectively, no restriction on disclosure of information imposed by any enactment or contract or otherwise shall prevent the disclosure of information to the competent authority pursuant to an approved agreement.
Yes, my lord, my submission in relation to that is that one has to look at the underlying agreement, and you've got to ask, is it necessary or expedient for the purposes of that agreement that information is to be provided, and that includes information that, if provided, will breach some provision, such as the privilege against self-incrimination. And if it does, then Section 4 operates so that it will be lawful. However, it's got to be necessary or expedient.
Yes.
And what we say is that it's not necessary or expedient for a very simple reason. And that is that the Jersey-Norway Tax Information Exchange Agreement enshrines the privilege against self-incrimination. And it says in terms that where the privilege applies, the privilege will take effect over the Tax Information Exchange Agreement. And I'll show your lordships why that conclusion is inevitable now. I was on the tax exchange information regulations. I don't think I'd taken you to all of the relevant provisions. If I could just go back, it was tab 4. I showed you regulation 10. Can I show you regulation 12?
Read the page for that again.
1612, my lord. Regulation 12 is an equivalent power to that in Article 2.4 of the 1991 Law Notice for the bailiff to issue a warrant for search and seizure. And the same point that we've already made applies. There's no offence if there is a reasonable excuse, and one sees that if one turns to Regulation 15 on page 1615. Subparagraph 3 on page 1616 over the page. A person who knowingly and without reasonable excuse fails to comply with the requirement imposed under Regulation 2.1 or 3.1 is guilty of an offence. And subparagraph 5, the penalty is an imprisonment of up to 12 months and a fine. So again, if the Article 6 privilege applies, then we respectfully submit there is a reasonable excuse. And if there's a reasonable excuse, there's no breach of the obligation under Regulation 3, and therefore the bailiff has no power to issue a search warrant because of the refusal. There may be other grounds on which a warrant can be obtained under other legislation, but that's merely to speculate. What one couldn't do is use Regulation 12.1a in circumstances where the privilege is properly raised under Article 6. And Regulation 16, my lords, this is relevant to our argument that the privilege should be enjoyed not just by Volaw, but also by its officers and directors, because by Regulation 16.2, if an offence under these regulations by a limited liability partnership, separate limited partnership or body corporate is proved to have been committed with the consent or connivance or to be attributable to any neglect on the part of a person who is a partner or director or manager or secretary or other similar officer, or any person purporting to act in such capacity, they also are guilty of an offence. So we respectfully submit that in circumstances where the NTA, the Norwegian Tax Authority, issued requests to investigate those who were involved in the running of those 9 companies, those involved included directors and other officers of Volaw. They were therefore not only suspects in a criminal offence, but they were also at risk of penalty if they failed to comply with the notices. And therefore, the privilege against self-incrimination applies not only to Volaw itself, but also to the officers and directors. And that's issue 6, which I won't now need to develop any further. So, my lords, and my lady, that is the relevant parts of the regulations. I think if I turn to the schedule, because the schedule contains those agreements that the regulations give effect to. And if you look at page 1625, the Jersey-Norway Tax Information Exchange Agreement is one of those that is given effect by the regulations. So now, my lords, my lady, we turn to the Jersey-Norway Tax Information Exchange Agreement itself. That is in volume 3 of the authorities. It's at tab 31, page 2635. And the first provision to draw to your lordship's attention is Article 1, scope of the agreement. It provides that the parties shall provide assistance through exchange of information that is foreseeably relevant to the administration and enforcement of the domestic laws of the parties concerning taxes. That includes in relation to the investigation of tax matters or criminal prosecution of tax matters. But it's the last 4 lines that I'd like to draw to your attention. The rights and safeguards secured to persons by the laws or administrative practice of the requested party remain applicable to the extent that they do not unduly prevent or delay effective exchange of information. And then Article 6 provides at subparagraph 4 the circumstances in which a requested party can refuse to comply with a request includes subparagraph 4, 2640. The requested party shall not be required to obtain and provide information which, if the requested information was within the jurisdiction of the requesting party, the competent authority of the requesting party would not be able to obtain under its laws or in the normal course of administrative practice. So, my lords, what one finds with the regulations read in the light of the agreement is a similar procedure to that which obtains under the Criminal Justice International Cooperation Law 1991 and the Crime International Cooperation Act 2003 here. That is to say, if a request is made by another country for information, there is no obligation to comply with that if the person is entitled to rely on the privilege in this country, or if they're entitled to rely on the privilege in that country. You find the same provision under the Exchange of Evidence in Civil Proceedings Act 1975, for example. So Article 1 and Article 6, between them, are read as meaning that the same rights that an individual already enjoys will continue to be enjoyed under the regulations giving effect to the agreement, to the effect that they do not unduly hamper the exchange of information. Do they unduly hamper? Well, my lords, that depends on how you read those provisions, but there is guidance as to how those provisions are to be read, provided by the OECD, under whose aegis the Tax Convention 1963 was first entered into, and under which a model tax convention with commentaries has been provided. And it's based on that model tax convention that the Jersey-Norway Tax Information Exchange Agreement is based. So if we look at...
Can I just ask you before we
yes.
look at anything else, does Jersey have the same dualist approach to treaties that the UK has? In other words, this would not be self-executing.
Yes.
Correct.
Yes.
It needs to be executed by primary legislation.
Fine, thank you.
Now, my lord, so the Jersey-Norway Tax Information Exchange Act agreement is made in the context of the obligations that Jersey and Norway have already made, in Jersey's case through the aegis of the United Kingdom, under the tax convention. And the tax convention itself provides section 26, subsection 3, essentially that rights are preserved. My lords, I'm not going to take you to them, but you'll find all of the relevant provisions set out in our case at paragraph 193. What I'll take you to now are the relevant provisions of the Model Tax Information Exchange Agreement by the OECD, which you'll find at volume 9 of the authorities. It's tab 98, page 4812. Tab 98, 4812. And Article 1 is at page 4815. And it includes its final sentence, the same wording as one finds in Article 1 of the Jersey-Norway Tax Information Agreement. The rights and safeguards secured to persons by the laws or administrative practice of the requested party remain applicable to the extent that they do not unduly prevent or delay effective exchange of information. And then Article 7, headed Possibility of Declining Request, is the analogue of Article 6 of the Jersey-Norway Agreement, and it's subparagraph 1 that's relevant. The requested party shall not be required to obtain or provide information that the applicant party would not be able to obtain under its own laws for purposes of the administration or enforcement of its own tax laws. And my lords, my lady, one finds a commentary to the Model Tax Convention, starting at page 4824, at the bottom of the page. And I'm going to ask you to go to two paragraphs. The first one is at paragraph 5 on page 4825, which explains that the last sentence of Article 1 ensures that procedural rights existing in the requested party will continue to apply to the extent... Sorry, my lord. Page 4825, it's paragraph 5 of the commentary. So I just ask your lordships to read that. Besides the last few words, such rights may take precedence over the agreement. And then paragraph 72 to 74. This is the commentary that relates to Article 7.1, which is the analogue of Article 6.4. The first sentence of paragraph 1 makes clear a requested party is not required to obtain and provide information that the applicant party would not be able to obtain under similar circumstances under its own laws. This rule is intended to prevent the applicant party from circumventing its domestic law limitations by requesting information from the other contracting party, thus making use of greater powers than it possesses under its own laws. For instance, most countries recognise under their domestic laws that information cannot be obtained from a person to the extent such person can claim the privilege against self-incrimination. A requested party may therefore decline a request if the applicant party would have been precluded by its own self-incrimination rules from obtaining the information under similar circumstances. In practice, however, the privilege should have little, if any, application in connection with most information requests. The privilege is personal and cannot be claimed by an individual who himself is not at risk of criminal prosecution. The overwhelming majority of information requests seek to obtain information from third parties, such as banks, intermediaries, or the other party to a contract, and not from the individual under investigation. Furthermore, the privilege generally doesn't attach to persons other than natural persons. My Lords, apart from that last sentence, and it's agreed between the parties that in fact Article 6 does apply to corporations, we endorse everything that is in that paragraph. And what it essentially says is the Jersey-Norway Tax Information Exchange Act agreement cannot be used to override any right that an individual has under the laws of his own country to rely on the privilege against self-incrimination. It also means that if Norway was not able to obtain this information itself because the privilege would be enjoyed in Norway, then Norway would not be entitled to this information. And my Lords, under issue 7, which I'm not going to develop, but I'll just highlight it now, issue 7 in this case is that Commissioner Volaw did not properly address his mind to that question because he did not obtain expert evidence to determine for himself whether Norway would have been able to obtain this information or whether the privilege against self-incrimination would have prevented the Norwegian tax authorities from doing so. So, my Lords, my Lady, that is the statutory framework within which these appeals are to be determined. And so I turn then to our first issue, the privilege against self-incrimination. I'm going to focus on Article 6 to start with, other than to just draw out some general points that apply both to common law and the Convention. And my Lords, it's probably easiest if I do this by taking you to the Beghal case, which you'll find in Volume 1 of the Authorities, at tab 11, page 1886. And it's to paragraph 60 of Lord Hughes's speech, Lord Hughes's judgment, I beg pardon, at page 1915. Now, this is a case that didn't involve documents. It involved a compulsory notice issued under the Terrorism Act, Schedule 7, to ask questions at a port, and it was accepted by it was determined by the Supreme Court that in any event there was no charge, the appellant wasn't charged. But these propositions of general application were made at paragraph 60. Firstly, that the privilege is firmly established judge-made law dating from the 16th century abolition of the Star Chamber. It entitles any person to refuse to answer questions or to yield up documents or objects if to do so would carry a real or appreciable risk of its use in the prosecution of that person or his spouse. See the Westinghouse case and Rank Film. If such level of risk exists, the individual should be allowed great latitude in judging for himself the effect of any particular question. And then at 61, a statute may, however, exclude this privilege in a particular situation and may do so either expressly or by necessary implication. Because the privilege is firmly embedded in the common law, such necessary implication must be established with clarity and is not to be assumed. And he then recites the classic exposition of the principle of legality in Sims. Now, my Lords, 2 points to make. The first one is that it's accepted that as a matter of Jersey customary law, the common law privilege also applies. See the case of Trant. I won't take you to it, but it's Volume 1, tab 6, 1652, paragraphs 40 to 42. The second point to make, my Lords, is that the story of the genesis of the domestic law privilege, of the common law privilege, as having arisen out of the abuses of the ecclesiastical courts of the ex officio oath during the 17th century, is largely down to the work of one man, Leonard Levy, in a famous book, The Origins of the Fifth Amendment. And there is powerful evidence to suggest that, in fact, it's of even greater antiquity. And I've put in your bundles, my lords, an article by Professor Richard Helmholtz, which you'll find at volume 9, tab 108, starting at page 5074. And what he says in terms is that while Levy's analysis is right in that the common law did indeed develop through a number of cases an antipathy for the ex officio oath, out of which came the privilege against self-incrimination, Helmholtz identifies the privilege, particularly in its Latin conception, nemo tenetur prodere se ipsum, as having much deeper roots. My lords, if anybody's got it up, it's page 5079, where he identifies the difficulties in Levy's account. And he says, first, second paragraph down, the ancient English common law principle forbidding compelled self-incrimination and the Latin maxim used to express it actually turn out to be commonplaces taken from the traditions of the European jus commune. Indeed, the maxim appears in that most basic of medieval guides to the canon law, the glossa ordinaria. The rule was repeated and endorsed by Innocent IV and Panomitanus, probably the two most influential writers on the medieval canon law. It was stated prominently in 16th century compendia of common conclusions from the jus commune, and it figured equally in contemporary continental manuals of civil and criminal procedure. My lords, why am I taking you to this? Well, for this reason. If that is correct, which there seems to be no reason why it's not, this right is over 800 years old. It's not just a couple of hundred years old. Secondly, of course, Jersey, since 1204, has been part of the English crown, in the sense that the Queen of England is the Queen of Jersey, but has continued with its own customary law, which of course is originally Norman. And that would have had as its roots the law of the jus commune. So in fact, in Jersey, the privilege against self-incrimination doesn't come via the English courts in the 17th century. It comes through the continental tradition that is 800 years old. And why is that important? Because, my lords, it is not a right to be taken away lightly. My lords, Helmholtz suggests that maybe that is why the privilege has become so firmly embedded not only as a common law principle and right in common law systems, but also in many, if not all, continental systems. And you will find in your bundles, I won't take you to it, volume 16, tab 159, an interesting article in Archbold Review.
Wait, what page?
It's volume 16, tab 159, 7052, a decision of the German Federal Constitutional Court discussing the privilege against self-incrimination under the German Constitution. But most significantly for our purposes, my lords, the privilege is guaranteed as one of the implied fair trial rights of Article 6. Now, my lords, what I propose to do is to take you now to the Article 6 case law. And if I could ask you to take up the document. I handed up, Well, Lords, you'll find 21 cases listed and a very brief summary of the facts of the cases and the key paragraphs. I'm not going to have time in the time available to me to take you to all of those, and so I would therefore ask you in due course when deliberating to consider all of those passages. What I start with is a number of propositions about what Article 6 establishes. First, the privilege applies to all forms of coerced evidence, including documentary evidence, real evidence, testimonial evidence. Secondly, at the pre-trial stage, the privilege requires either that a person charged with a criminal offence is not compelled to provide statements or documents under threat of punishment, or if he is, that he has an enforceable use immunity preventing the use of that evidence in subsequent criminal proceedings. So you can ask the question, you can compel the evidence, but you've got to give a use immunity. Now, my lords, thirdly, the right is not an absolute one. And there may be exceptional circumstances in which compelling a person to provide information under threat of punishment and to then use it does not breach Article 6. But there's only been one circumstance in which that is found to be the case, and that is in relation to the driving cases, O'Halloran, Way, Brown and Stott, where only a single piece of information was being sought under relatively minor compulsion. In all other cases, the compulsion itself, the compulsion to comply with a demand for documents or statements under pain of punishment is considered to be undue coercion. Fourth, the privilege does not apply to documents obtained by search and seizure, which is in fact the same as the position is at common law. Fifth, the rationale for the protection is wider than merely the avoidance of coerced and therefore potentially unreliable confessions. It is also aimed at avoiding the use of undue coercion by the state and giving primacy to the presumption of innocence. Sixth, the Strasbourg Court has specifically disavowed the approach of those jurisdictions that have limited the privilege to testimonial evidence only. And therefore, we say that the criticisms that you will find in many of the cases, starting with Lord Templeman's characteristically trenchant observations in AT&T, Istel and Tully, included by Lord Hoffman in the Green Environmental Industries case, and also by Lord Justice Lawrence Collins, as he then was in the CPLC and P case, where they all said in terms they didn't see what the need was for the privilege in relation to documents, because the same issues did not arise in relation to compelling testimony as it did in relation to compelling documents, because there wasn't the same risk of coercion and therefore miscarriages of justice. That reasoning simply does not bite in the context of Article 6, because the rationale for the privilege under Article 6 is a wider one. My Lords.
Will you be explaining at some stage, and I don't wish to take you out of order, why a broad interpretation of the protection of people against coercion doesn't apply to search and seizure? I will. You will. Okay. Well, I won't take you out of order.
But I can give you a summary now, my Lord.
I'm happy to wait.
I'm very grateful. Well, before I start the chronology, I'll start by this proposition that the privilege against self-incrimination applies at two stages in a criminal investigation. It applies at the trial stage in relation to the use of any compelled information that is obtained, but it also applies at a pre-trial stage, and one gets that most effectively from the case of Way and Austria. I won't take you to it. It's paragraphs 41 to 43 of Way and Austria, volume 8, tab 89, page 4500. But it's important because in the Green Environmental Industries case, the error that we respectfully submit that was made and which it appeared that the respondent accepted had been made, was to suggest or to hold that the Article 6 privilege only applied at the trial stage. It also applies at a pre-trial stage if and only if the individual is charged with a criminal offence and the authorities are seeking to compel them to provide information in relation to that charge under pain of criminal sanction. So the first case for the proposition that that applies to documents is Funke in France. I will take you to that, my lords. Volume 2, tab 24, page 2307. But if I just take you straight to the guts of it, paragraph 44 of the judgment, page 2336. You'll see from paragraph 44, my lord. You'll see from the brief summary that I've handed to you, I've put in the reference to the commission proceedings in which they decided why it was that Mr. Funke was charged with a criminal offence. The reason why that is relevant is because in the Green Environmental Industries case, Lord Hoffman asked the question rhetorically, what was the offence with which they were charged? But that was part of his criticism of this decision. But you'll find it in those parts of the Commission's decision. So paragraph 44, this is the fons et origo of the proposition that it applies to documents. The court notes that the Customs secured Mr. Funke's conviction in order to obtain certain documents which they believed must exist, although they were not certain of the fact. Being unable or unwilling to procure them by some other means, they attempted to compel the applicant himself to provide the evidence of offences he had allegedly committed. And then this, the special features of customs law cannot justify such an infringement of the right of anyone charged with a criminal offence within the autonomous meaning of this expression in Article 6, to remain silent and not to contribute to incriminating himself. Therefore, there's been a breach of Article 6. The next case is Murray, where this passage was considered, and an important passage explaining the difference between some kinds of compulsion and others. Murray is at volume 8, tab 84, and it's at page 4339. But the relevant passage is 49 to 50, which your lordships will find at 4371. Now, Murray, your lordships will all know well, this was the case where the introduction of adverse inferences from silence by the 1994 Criminal Justice Act was challenged, and it was suggested that by placing an individual under compulsion, by informing them that an adverse inference could be drawn, they were effectively being compelled against their will to give evidence, and that breached Article 6. And at paragraph 49, the court said this: the facts of the present case fall to be distinguished from those in Funke, where criminal proceedings were brought against the applicant by the customs authorities in an attempt to compel him to provide evidence of offences he'd allegedly committed. Such a degree of compulsion in that case was found by the court to be incompatible with Article 6, since in effect it destroyed the very essence of the privilege against self-incrimination. Admittedly, a system which warns the accused, who is possibly without legal assistance, that adverse inferences may be drawn from a refusal to provide an explanation to the police for his presence at the scene of a crime or to testify during his trial, when taken in conjunction with the weight of the case against him, involves a certain level of indirect compulsion. However, since the applicant could not be compelled to speak or to testify, as indicated above, this factor on its own cannot be decisive. The court must rather concentrate its attention on the role played by the inferences in the proceedings against the applicant, and especially in his conviction. So, my lords, what's important about this case is that it draws a distinction between the indirect compulsion that arises from being told that adverse inferences can be drawn, which is not sufficient to cross the threshold for Article 6 purposes under the privilege under Article 6.
Funke, I'm afraid I've been reading Funke, and it strikes me it's a rather unusual case. What the French authorities were wanting were documents held the documents of bank accounts held in overseas countries. And the reasons given for the judgment condemning Mr. Funke in France were that he'd failed to show that he'd taken the necessary steps to obtain the required documents from the foreign banks, or to prove that the foreign banks had refused to supply him with the documents. So he's been condemned, he's been convicted and punished in France, not for failing to hand over documents in his possession, but for failing to obtain the documents from banks overseas, saving the French authorities either the trouble of doing that, or it may be if there wasn't a mutual assistance treaty at the time, they might have been unable to obtain the documents by themselves.
Except that is a distinction, but it's my submission, it's a distinction without a difference when one looks at the way that the jurisprudence develops. I've given you the references as to when the reference to the Commission consideration, which is a necessary precondition to reading the court's decision, because it was one of those decisions at a time when the Commission contained very much more reasoning than the court did. But Funke, when looked at in the later judgments, is taken as an illustration of a case where a person has been compelled to hand over documents in their possession or in their custody or control, at least, under pain of criminal sanction for the purposes of a criminal investigation when they're charged with the criminal
That may in fact be a
offence.
mischaracterisation of the case.
I beg your pardon?
That may be a mischaracterisation of the case. That's what later jurisprudence may say, but as Lord Reid says, that doesn't seem to be what Funke was about.
My Lord, what my submission will be is that what one has to do with Strasbourg cases is that it's not unusual for a later Strasbourg case to interpret an earlier decision and to give it a meaning that it might not necessarily at first blush have when you read the decision in isolation. And what we have with this issue is a number of cases. I've given you 21 cases where Funke is either referred to with approval or is directly applied, where it is treated as an example of a criminal suspect being compelled to hand over documents under pain of punishment.
But your argument is based on the degree of compulsion. But this case of Murray specifically rejects that argument.
No, what it does, it specifically endorses that argument, my lady, but what it says is that it depends on the degree of compulsion.
No, with respect, if you look at 49, it ends up by saying such a degree of compulsion in this case was found by the court to be incompatible with Article 6, since, i.e., because, in effect, it destroyed the very essence of the privilege against self-incrimination. Now, the next paragraph, they go on to deal with the question of the appellant being compelled to speak or testify, but they say this factor cannot be decisive. The court must rather concentrate its attention on the role played by the inferences in the proceedings against the applicant and especially in his conviction. So the focus here is not on the degree of compulsion, but on the role played by the information that is produced under the compulsion to see whether or not that has destroyed the very essence of the privilege against self-incrimination. So if, to put it bluntly, if the prosecution cannot get a conviction except by using information obtained under compulsion, that is a breach, a violation of Article 6, but not otherwise.
The distinction that's being drawn, my lady, is this, between the direct compulsion in Funke in France, which was found to have, in effect, destroyed the very essence of the privilege, with the indirect level of the certain level of indirect compulsion in Murray's case, which did not. So the point is that we have to look at the degree of compulsion,
yes,
and the degree of compulsion that is in asserted or applied directly by imposing a compulsory requirement to hand over documents under pain of criminal sanction is of a nature or degree of compulsion crosses the threshold.
Well, with respect, I don't think that they are focusing on the degree of compulsion. They're looking at the result in the trial process. What role, that's the very point at the end of 50, have the answers or the information, or whatever format, what role has it played? And if, as I say, it was something without which the conviction could not have been obtained, then there must be a violation.
There are essentially three factors that the court looks at, and I'm going to be taking you to the relevant passages, and it's really necessary to look at all of these judgments in the way that the point has developed over time to really understand what is meant in these cases. And that's why I need to take your lordships through all of these, and then I will draw out the conclusions that I seek to draw from them.
It's not only the degree of compulsion in Murray, it's also the nature of the compulsion, because Mr. Murray, like all defendants who were confronted with this legislation, had a choice. He could choose to say nothing and run the risk of an adverse inference being drawn against him, or he could choose to say something. So it's not simply a question of the degree of compulsion, because that will depend upon the particular facts of the case. It's the nature of the compulsion. It's not a direct compulsion, it's an indirect one.
That's absolutely right. And my lord, the case I'm going to take you to in due course is Ibrahim, where the Grand Chamber, after reviewing all of the authorities, says exactly that what is of the essence is the nature or degree of compulsion that is applied. And when we get to Saunders, and more particularly when we get to the cases that re-examine Saunders, what you essentially find in Saunders is a bifurcation between those forms of evidence that are obtained by means of compulsion that do not cross the threshold, and those that are obtained by a form of compulsion that do. And that will be the distinction that I am going to draw between the two categories in Saunders. But my lords, with your leave...
If one's looking at Funke, from that perspective, it's very striking how Mr. Funke was being proceeded against time and again by the authorities and subjected to successive fines, indeed fines on a daily basis. It doesn't
need lots of incidences. In Shannon, for example, it was a single request which resulted in a single conviction. So that just goes to the question of what is the degree of compulsion. Yeah. It doesn't go to the question of does putting somebody in the cruel trilemma, which is not a phrase, granted, that has been used by the Strasbourg court, but is the phrase that's used by Lord Nichols in Brannigan, taken from the case of Murphy, the cruel trilemma of perjury, incrimination, or contempt. Now, it's that cruel trilemma, which we respectfully submit, is a form of compulsion that is of a nature or degree that it will invariably, other than in exceptional circumstances, it will invariably amount to a breach of the privilege. And indeed, it will only not amount to a breach of the privilege in the very limited circumstances that one finds in cases like O'Halloran and Brown and Stott. So that is the point, that subjecting somebody to the cruel trilemma, which is the phrase we use time and again in our case, and I'm going to use it here, even though it's not the phrase you find the Strasbourg court using. But that is what they're talking about. When you put somebody in a situation where they've either got to confess or hand over documents which incriminate them, or they've got to lie and say they don't have them, which creates a risk of perjury, or they get convicted of a criminal offence for failing to hand them over. It's that psychological pressure which has been held time and again by the Strasbourg court to be sufficient to engage the privilege. And it should be no surprise, my lords, my lady, because that's precisely why the privilege developed at common law. It's that psychological pressure that is generated by placing somebody in the cruel trilemma that means the privilege developed and applies at common law, and it's also the reason why it applies under Article 6. My Lords, the next case is Saunders. Saunders is the most difficult of the cases, and it's necessary to look at Saunders in the light of later cases, and with your Lordship's leave, I will simply show you the paragraphs. You've seen them many times already because they're set out in our case, but they are set out at Volume 3, tab 29, page 2567. It's page 2591. Now, bear in mind that these two matters about Saunders. Saunders was a statements case, wasn't a documents case, and it was a case involving the use of statements obtained under compulsion at trial. So it's not a pre-trial case. And the mistake, with the greatest respect, that was made by the House of Lords in Green Environmental Industries was to conclude from that the privilege only applied at the trial stage. But it's paragraph 68. The court recalls that, although not specifically mentioned in Article 6, the right to silence and the right not to incriminate oneself are generally recognised international standards which lie at the heart of the notion of a fair procedure under Article 6. Their rationale lies, among others, in the protection of the accused against improper compulsion by the authorities, thereby contributing to the avoidance of miscarriages of justice and to the fulfilment of the aims of Article 6. The right not to incriminate oneself in particular presupposes that the prosecution in a criminal case seek to prove their case against the accused without resort to evidence obtained through methods of coercion or oppression in defiance of the will of the accused. In this sense, the right is closely linked to the presumption of innocence contained in Article 6.2 of the Convention. Now, what we say, my Lords, is that evidence obtained through methods of coercion or oppression in defiance of the will of the accused, whether a particular measure falls within that definition, will depend on the nature or degree of coercion that is applied.
Which lines are you referring to?
These last four lines of paragraph 68.
That's talking about getting a conviction without resort to evidence obtained through methods.
Through methods of coercion or oppression, that's right.
So if you've got a conviction using the evidence, but without it being tipping the balance into conviction.
It shouldn't be obtained in the first place against somebody who is a suspect in criminal proceedings. That's the decision in way. That is not an issue between the parties. That's why I've not sought to demonstrate that point. This is a trial case, but if one applies this to the pre-trial process, then the prosecuting authorities should not use they should not use methods of coercion or oppression in defiance of the will of the accused in order to obtain evidence, whether there's a criminal trial in the final analysis or not. But the test for whether a particular measure falls within that sentence depends on the nature or degree of coercion that is employed. And then, therefore, when one turns to paragraph 69, the right not to incriminate oneself is primarily concerned, however, with respecting the will of an accused person to remain silent. As commonly understood in the legal systems of the contracting parties and elsewhere, it doesn't extend to the use in criminal proceedings of material which may be obtained from the accused through the use of compulsory powers, but which has an existence independent of the will of the suspect, such as, among others, documents acquired pursuant to a warrant, breath, blood and urine samples, and bodily tissue for the purposes of DNA testing. Now, my Lords, what we submit this means is that evidence can be obtained independently of the will of the suspect, that's to say, without the need to overbear the suspect's will, in a number of ways in a criminal investigation. That includes by obtaining evidence pursuant to a warrant, pursuant to a measure that obtains breath, blood, urine, samples and bodily tissue. Now, what the court is saying in that passage, as interpreted in the later passages to which I'll need to take you, is that evidence obtained by any of those means is not of a nature or degree to amount to undue coercion. Now, documents acquired pursuant to a warrant, of course, will be obtained under threat of the use of reasonable force. And what this amounts to, my lords, is the court accepting that some degrees of coercion do not engage the privilege. So to obtain evidence through a threat of the use of reasonable force, whether it's to obtain evidence by way of a search warrant, whether it's to obtain breath, blood, and urine samples, or other bodily tissue for purpose of DNA, if it's done under the threat, well, look, if you don't agree, we've got compulsory powers to do this, that does not cross the threshold for the engagement of the privilege against self-incrimination. And my lords, again, it should not be too surprising, because as a matter of domestic law, common law, evidence obtained by way of a search warrant has never engaged the privilege against self-incrimination. And the same is true under Strasbourg law.
But if the test is coercion and overbearing someone's will, why does the existence of the warrant make a difference?
Because the warrant authorises the state to use reasonable force to go in and take documents if the individual who is the subject of the warrant does not agree.
If the individual doesn't agree?
If the individual doesn't agree. So they are in the position where they are subject to a degree of indirect compulsion, not a million miles from the suspect in the Murray-type situation, but that degree of indirect compulsion that comes from being under threat of the use of reasonable force does not suffice to bring that form of evidence gathering within Article 6.
Is the only compulsator of a search warrant the use of reasonable force? Are there not criminal sanctions if you resist a search?
My lord, that is a question which the jurisprudence does not provide an answer to. And there's another question to which the jurisprudence does not provide an answer as well, which is this. If somebody uses a degree of force to obtain, for example, breath, blood, or bodily samples that crosses the Article 3 threshold, the Strasbourg Court has accepted, in the case that I'm next going to take you to, Jallow and Germany, that will engage the privilege against self-incrimination. And that is because some evidence can be obtained in ways that do not engage the privilege, because the degree of indirect compulsion does not cross the threshold. But if a degree of compulsion is used that is undue, for example, as in Jallow, administering an emetic to force a drug smuggler to vomit up the drugs that he had in his stomach, that will take a piece of evidence which might have been obtained by means that fell within Category 2, what is called the real evidence exception in Jallow, and I'll come to it in a moment. It takes it out of that category into the category of evidence that's obtained by coercion or undue, by means of undue coercion. So it's not a hard and fast distinction that's being drawn. It depends, as my Lord Kerr pointed out, on the nature or degree of coercion. Now, if I can take you next to Jallow, because...
Sorry, my question may not have been clear, but in our domestic law in England and Wales, or if we have the information in Jersey, as far as you know, there is no criminal offence for resisting officers acting under a search warrant. Is that right?
My Lord, I can't assist you with that.
Well, if nothing else, they might be charged with obstructing a police officer in execution of his duty.
I would have thought so.
That may be so. I mean, the point is, my Lord, is that what the distinction that was drawn in Saunders was Delphic. I completely agree with the criticisms that are made by, for example, Lord Steyn when he was looking at this in Brown and Stott about the distinction that's made in Saunders. It's not until you look at the later case law that you can understand what it is, and it's only on the basis of that later case law that I make the submission that I do. And so, my lords, I'm not going to take you to, if we just look at the cases in the list before you, L and the United Kingdom, my lords, that is an anomaly. It's an admissibility case, and for the reasons we've set out in our supplementary case, is an anomaly because it's the only case where you will find the recitation of what you find in paragraph 69 of Saunders, but where the words acquired pursuant to a warrant are not present. So in every other case, those words that you see in paragraph 69 of Saunders, such as inter alia documents acquired pursuant to a warrant, breath, blood and urine samples, it's the only case where you don't find those words acquired pursuant to a warrant. And my lords, that absence is striking and critical, because for the reasons that I've sought to explain and I'm going to develop further, documents do fall within, or can fall within, the privilege when they are obtained by means of coercion that is considered to be undue. And means of coercion that are considered to be undue include putting somebody in the cruel trilemma of perjury, self-incrimination, or contempt. So, my lords, the Heaney and Guinness and McGuinness and Ireland is an important case. I've highlighted the relevant passages, but I'm not going to take you to them. JB in Switzerland, my lords, is an important case, not least because it is a documents case on precisely the point that this case is concerned with. That is to say, an applicant was a suspect in criminal tax evasion proceedings. He received requests or demands for tax information which, failure to comply with amount, resulted in a criminal sanction, albeit a relatively small one of 1,000 francs the first time and 2,000 francs the second time. But the Strasbourg court held that the applicant firstly had been charged with a criminal offence, namely the tax evasion proceedings culminating in the fine, and they found that there had not been compliance with Article 6. And if I can take you to that judgment, starting with that part of their decision, at page 2533, Volume 3, tab 27. And again, my lords, I don't have time to take you through the court's reasoning as to why Mr. JB was charged, but that was the finding of the court. But on the question of compliance, the court's reasoning, the court's reasoning begins at paragraph 59. So you've got the applicant submissions and the government submissions. Paragraph 59. The government considered that in such cases, as a matter of political choice, the tax authorities had no powers of investigation so as not to penalise the person concerned. They could not search a person's premises, confiscate objects, hear witnesses, or order detention. Bank secrecy remained intangible. To compensate for these shortcomings, the authorities could oblige a person to furnish relevant documents. The fine provided for in Article 131 of the federal decree was the only coercive measure left to the authorities. In this respect, the government distinguished the present case from Funke, where the French authorities imposed more severe fines and had far-reaching powers, such as that of searching premises and confiscating documents. The government submitted that a separation of the proceedings as practiced, for instance in Germany, regular tax proceedings on the one hand and criminal tax evasion proceedings on the other, would be impractical, as the administration would have to conduct two different sets of proceedings and the taxpayer would have to defend himself twice. The additional problem arose as to whether or not information gathered in the regular tax proceedings could be used. Indeed, if a breach of Article 6 of the Convention were to be found in the present case, the legislative changes would be disproportionate and would not serve the cause of human rights, since the tax authorities will be obliged to resort to all the means normally reserved for the criminal investigation organs. So the government's argument was, well, this is actually relatively benign, that we only require documents to be obtained by way of an information notice. We don't have any powers of search and seizure, for example. But that was an argument that did not find favour. So the court's assessment begins on paragraph 63. The court recalls at the outset that in proceedings originating in an individual application, it has to confine itself to an examination of the concrete case. Accordingly, what is at stake in the present case is not the fairness of the proceedings as such, which were instituted against the applicant. Rather, the court is called upon to examine whether or not the imposition of a fine on the applicant for having failed to provide certain information complied with the requirements of the Convention. It follows the court is not deciding in the present case the issue whether a state can oblige a taxpayer to give information for the sole purpose of securing a correct tax assessment. Now, my lords, the answer to that is yes, they can. Cases like Allen and King, the courts have made very clear that as long as the demand is being made of somebody who's not a suspect in a criminal offence, then the state can make demands backed by criminal sanctions. Paragraph 64, the recitation of the general principles, but again citing Funke, and then picking up at paragraph 66. Thus, it appears that the authorities were attempting to compel the applicant to submit documents which would have provided information as to his income with a view to the assessment of his taxes. Indeed, according to the Federal Court's judgment of 7th of July, it was in particular important for the authorities to know whether or not the applicant had obtained any income which had not been taxed. While it's not for the court to speculate as to what the nature of such information would have been, the applicant couldn't exclude that if it transpired from these documents that he'd received additional income which had not been taxed, he might be charged with the offence of tax evasion. So he was a suspect in tax evasion proceedings, and the disclosure of this information put him at risk of being charged. In paragraph 68, the court notes that in its judgment of 7th of July 1995, the Federal Court referred to various provisions in criminal law obliging a person to act in a particular way so as to enable the authorities to obtain his conviction. For instance, the obligation to install a tachograph in lorries or to submit to a blood or a urine test. In the court's opinion, however, the present case does not involve material of this nature, which, like that considered in Saunders, has an existence independent of the person concerned and is not, therefore, obtained by means of coercion and in defiance of the will of that person. Now, my lords, difficult though the syntax of that sentence is, what it essentially means is that the court rejected the argument that what the authorities were seeking to do was to obtain information which had an existence independent of the will of the person. They said, no, this is not such information. That's information of the kind that was referred to in Saunders, documents acquired pursuant to a warrant or acquired breath, blood and bodily samples, and a tachograph is given as the other example. And now the distinction is, and although it's not said in this passage, of course, it comes down to the nature or degree of compulsion. And what the court is saying is the nature or degree of coercion that is involved in the cruel trilemma takes this out of the category of evidence that's independent of the will of the person and into the category of evidence that's obtained by means of undue coercion.
Not very logical, is it? I mean,
I beg your pardon.
well, whether the document has independent existence isn't affected by whether you obtain it by a warrant or by some other means, so,
Yes, well,
or by the degree of coercion, so it doesn't seem to make much sense.
The concept of a document having an existence independent
Yeah.
is one that has caused a lot of confusion. Now, there's a big difference between information with an existence independent of the mind of the individual, which is essentially what it was interpreted as meaning in the Attorney General's reference case. So, drawing the distinction between testimonial evidence and documents, one has an existence independent of the mind or memory of the individual. That's not the distinction that's being drawn in Saunders. It's information or evidence which has an existence independent of the will of the person. That's to say, it can be obtained without overbearing the individual's will in a way which amounts to undue coercion. And in that sense, it is independent of the will of the person.
Well, I'm not sure on its I speak about existence at all. I mean, when I read this passage in preparation for this hearing, it struck me that paragraph 68 simply didn't explain the basis of the court's opinion.
Well, my lord, what they are saying is that it doesn't fall into Saunders Category 2, that was the submission that was made by the government, and they said, no, it...
I mean, we understand that they were saying it didn't fall into that category. What we're finding difficulty is what the explanation that's given, and it's not your fault, but there it is.
If I can say this, I sympathise. I've had the same difficulties.
Good.
In fairness to the court, I mean, this wasn't a this is not a straightforward documents case. It started off with the discovery by the tax authorities that this applicant had invested in various companies, paragraph 9, but had failed to declare the investments in his tax returns. And so the first thing they do in paragraph 10 is ask him to submit all the documents which he had concerning those companies. So he then admits that he's made the investments and has failed to declare the income in his tax return. The authorities then ask him a rather different question. What's the source of the income that you invested? Paragraph 12. There's a further request for an explanation of the source of the income, paragraph 14. And so it goes on with repeated requests for that. And in paragraph 30, when it eventually reaches the federal court, says that in the present case, the purpose of the intervention by the authorities was to ascertain whether the income stemmed from income or assets which had been duly taxed. All the applicant had to do was to explain the source of this income. Mm-hmm. So it's, although the court itself talks about information in paragraph 63 and again in 69, it's true it refers to documents in 66, but this isn't simply a documents case, as Funke was.
Well, my lord, of course, I accept that this is a mixed case, but what I'm seeking to do is to draw out from a series of judgments the principle as to how to understand the distinctions that have been made, and I don't shy away from this proposition that it's not easy. The Strasbourg court has not spoken in a way that has made it easy to understand the distinction between material that's obtained by means of undue coercion in defiance of the will of the suspect on the one hand, and information which has an existence independent of the will of the suspect. I accept that.
The passages you've shown us only deal with applicability of Article 6, whether they were civil or criminal proceedings. We do have to go on and look at the application on the merits.
My lady, what the court has done is that in those cases where it has found that there has been direct compulsion to comply with a demand for information, whether it's statements made or documents, by way of a compulsory demand backed by criminal sanctions, it has always gone on to find that there is a breach of the privilege under Article 6, except in very exceptional circumstances, namely in the cases like Brown and Stott, O'Halloran, which are the driving cases. And so, my lady, while you're right that crossing the threshold to fall within evidence of which has been obtained by means of coercion in defiance of the will of the suspect is not the end of the analysis. In all other cases, it has been, in practice, the end of the analysis. And
Well, with respect, I think we've got to look at 72 and 73, where they deal with the compliance and the question of violation.
So, my lady, I was at paragraph 68. Mm-hmm. So then if we look at paragraph 70, in fact 69, the government had further submitted that the applicant had not been obliged to incriminate himself since the authorities were in fact already aware of the information in question and he'd admitted the amounts concerned. The court remains unconvinced by this argument in view of the persistence with which the domestic tax authorities attempted to achieve their aim. Thus, between 1987 and 1990, the authorities found it necessary to request the applicant on 8 separate occasions to submit the information concerned. and when he refused to do so, they successfully imposed altogether 4 disciplinary fines on him. Finally, the government have submitted that a separation of proceedings, regular tax proceedings on the one hand and criminal tax evasion proceedings on the other, would be impractical. The court recalls that its task is to determine whether the contracting states have achieved the result called for by the Convention, not to indicate which means a state should utilise in order to perform its obligations under the Convention. So that was in response to the government's argument, which was, well, look, if we can't use this power under Article 131, we're going to have to introduce other means of obtaining this information, for example, by way of search warrants. And the court's answer was, all we have to do is to tell you that the mechanism that you're currently using does not comply, and it does not comply. And then, conclusion, my lady, paragraph 71, as a result and against the above background, the court considers there's been a violation of the right under Article 6.1. So, my ladies, my lord, on your list, I've mentioned Allen and the United Kingdom and King in the United Kingdom. They're important because they are cases which demonstrate that simply compelling somebody to answer questions concerning their tax affairs, for example, does not engage the privilege. It's only if that person is charged with a separate criminal offence that it does so. My lord, my lady, Allen in the United Kingdom, that's A-L-L-A-N, that's at number 9. That's a different set of facts, but there's an important paragraph that I do want to take you to, which demonstrates the point that I have been seeking to make, that it's about the degree to which a person's will is overborne that is relevant. So if you could turn to...
But did you take us to the line 4 on that page of your helpful note? You in the part underscored in blue.
Yes,
it
I've
refers
taken
to
you
two
to
paragraphs where they destroyed the very essence of the right.
And paragraph 70. No, actually, I think that's a mistake. Actually, my lady, I think that's taken from another case. That is the end of that case. I think those are the paragraphs in a later case called
Martin N.
Martin N. Yes. I'm terribly sorry. If you could just strike those 2 paragraphs through in your note.
Well, they are. Those words are there in Martinen.
But they're in Martin.
Yeah. So perhaps not strike them through, but put a note that's in Martin.
It's in Martin, yes, exactly. So Allen in the United Kingdom, it's volume 13, tab 136 at 6262. But if I could ask you to pick it up at 6275. This is a very different set of facts. The applicant was arrested for murder. He exercised his right to silence, and he was put in a cell with covert listening devices and a police informant. And he made admissions to the police informant that were later used in evidence against him. So it's not the facts of the case that are in any way relevant. It's the reasoning by which the court reached its conclusion that is important. So paragraph 6275, there is a citation which includes, sorry, no, it's not 45. If we go on to paragraph 50, page 6277. While the right to silence and the privilege against incrimination are primarily designed to protect us against improper compulsion by the authorities and the obtaining of evidence through methods of coercion or oppression in defiance of the will of the accused, the scope of the right is not confined to cases where duress has been brought to bear on the accused or where the will of the accused has been directly overborne in some way. So I'd highlight that line. The will of the accused has been directly overborne in some way. So those are cases which do engage the privilege. The right, which the court has previously observed, is at the heart of the notion of a fair procedure, serves as principle to protect the freedom of a suspected person to choose whether to speak or to remain silent under police questioning. Such freedom of choice is effectively undermined in a case in which the suspect, having elected to remain silent during questioning, the authorities use subterfuge to elicit from the suspect confessions or other statements of an incriminatory nature, which they were unable to obtain during such questioning, and where the confessions or statements thereby obtained are adduced in evidence at trial. And then paragraphs 52 to 53, 52 on page 6278, towards the bottom of that that paragraph. It's about 10 lines up, beginning, while it is true that there was no special relationship between the applicant and H and that no factors of direct coercion have been identified, the court considers that the applicant would have been subject to psychological pressures which impinged on the voluntariness of the disclosures allegedly made by the applicant to H. He was a suspect in a murder case in detention under direct pressure from the police and interrogations about the murder, and would have been susceptible to persuasion to take H, with whom he shared a cell for some weeks, into his confidence. In those circumstances, the information gained by the use of H in this way may be regarded as having been obtained in defiance of the will of the applicant, and its use at trial impinged on the applicant's right to silence and privilege against self-incrimination. So, my lords, you can breach the privilege by bringing duress to bear on the accused, where you overbear their will in some way, such as, for example, by way of imposing the cruel trilemma. But it's also possible to bring to bear indirect psychological pressures, which can also cross the threshold necessary to engage the privilege. That is Allen in the United Kingdom. Then, if I could take you to Shannon against the United Kingdom, which is at volume 8, tab 87. And the page to take you to is at 4449. My lords, my lady, this was not a document case. This was a case where the defendants were obliged to give evidence under the crime.
Can you give me the tab number again?
Sorry, 4449.
887, volume 887.
4449. You see that this was the case in which the provision obliged statements to be obliged the individual to answer statements, and there was a limited use immunity along the same lines that one finds in Article 2, subsection 7 of the 1991 law. But if we pick it up at paragraph 40 on page 4453, this was concerning the question of whether the information, whether the procedural protection in relation to the statements that were made under compulsion was sufficient for Article 6 purposes. So paragraph 39, top of the page, as to the procedural protection available to the applicant if he had attended the interview and if he had subsequently wished to prevent the use of information given in criminal proceedings, the court first notes that it would have been open to the investigators to forward information to the police, even though, as the government says, the two investigations were being run separately. Once the information had been passed to the police who were working on the criminal proceedings against the applicant, they would have converged, at least as far as the applicant was concerned. So there was no use immunity. That's the point about paragraph 39. And then 40, secondly, the court notes that the information obtained from the applicant at interview could have been used at a subsequent criminal trial if he had relied on evidence inconsistent with it. Such use would have deprived the applicant of the right to determine what evidence he wished to put before the trial court, and could have amounted to resort to evidence obtained through methods of coercion or oppression in defiance of the will of the accused. So, my lords, that's the point. I mentioned Shannon when I was showing you Article 2.7 and the absence of an equivalent to Section 2.8AA of the 1987 Act. So, my lords, the next case...
Why does this case help us?
I beg your pardon?
Why does this case help us, Shannon?
It's paragraph 39, particularly in relation to the absence of a use immunity. So the absence of a use immunity is a feature. If a use immunity is granted that is enforceable, then there'll be no breach. But if there's no use immunity, then there will be a breach. Then it's the Grand Chamber decision in Jallow, which is volume 3, tab 26, 2473. But if I could ask you to pick it up at paragraph 97 on 2497. This is a Grand Chamber decision. It's the first of 3 Grand Chamber decisions, which I'll take you to. Paragraph 97, the general requirements of fairness contained in Article 6 apply to all criminal proceedings, irrespective of the type of offence at issue. Nevertheless, when determining whether the proceedings as a whole have been fair, the weight of the public interest in the investigation and punishment of the particular offence at issue may be taken into consideration and be weighed against the individual interest, the evidence against them be gathered lawfully. However, public interest concerns cannot justify measures which extinguish the very essence of an applicant's defence rights, including the privilege against self-incrimination. And picking it up at paragraph 100, as regards the use of evidence obtained in breach of the right to silence and the privilege against self-incrimination, the Court recalls that these are generally recognised international standards which lie at the heart of the notion of a fair procedure. Their rationale lies, among others, in the protection of the accused against improper compulsion, etc. So that's the general principle we've seen before. Paragraph 101, in examining whether a procedure has extinguished the very essence of the privilege against self-incrimination, the Court will have regard in particular to the following elements: the nature and degree of the compulsion, the existence of any relevant safeguards in the procedures, and the use to which any material so obtained is put. Now that is the critical test to be applied. Paragraph 102, the Court has consistently held, however, that the right not to incriminate oneself is primarily concerned with respecting the will of an accused to remain silent. As commonly understood in the legal systems of the contracting parties to the Convention and elsewhere, it doesn't extend to the use in criminal proceedings of material which may be obtained from the accused through the use of compulsory powers which has an existence independent of the will of the suspect, such as, among others, documents acquired pursuant to a warrant, etc. So there's category 2 of the of Saunders. And if we pick it up at paragraph 109, the Court had already found at paragraph 108 that the use of the in evidence of the drugs obtained by the forcible administration rendered the trial unfair. But they then went on to consider whether there was also a breach of the privilege. This finding, they said, is of itself a sufficient basis on which to conclude the applicant was denied a fair trial. However, it considers it appropriate to address also the applicant's argument that the manner in which the evidence was obtained and the use made of it undermined his right not to incriminate himself. To that end, it will examine first whether this particular right was relevant to the circumstances of his case and whether it's been breached. And these next 2 paragraphs, my lord, my lady, are very important. As regards the applicability of the principle against self-incrimination in this case, the Court observes that the use of the trial of real evidence, as opposed to a confession, obtained by forcible interference with the applicant's bodily integrity, is at issue. It notes that the privilege against self-incrimination is commonly understood in the contracting states and elsewhere to be primarily concerned with respecting the will of the defendant to remain silent in the face of questioning and not to be compelled to provide a statement. So that is an acknowledgement that in most cases there needs to be some testimonial aspect for the privilege to be engaged. However, the Court has on occasion given the principle of self-incrimination as protected under Article 6 a broader meaning, so as to encompass cases in which coercion to hand over real evidence to the authorities was at issue. In the Funke case, for instance, the Court found that an attempt to compel the applicant to disclose documents and thereby to provide evidence of offences he had allegedly committed violated his right not to incriminate himself. Similarly, in JB in Switzerland, the Court considered the state authorities' attempt to compel the applicant to submit documents which might have provided information about tax evasion to be in breach of the principle against self-incrimination in its broadest sense. So, my lord, my lady, what the Court is saying is that, that there is not this, there is not a requirement for a testimonial aspect to the evidence for the privilege to be engaged. What is important is the nature of the compulsion to which the individual is subjected. So paragraph 1112, they consider the Saunders case. The Court considered that the principle against self-incrimination did not cover, and then we have the familiar passage from paragraph 69 of Saunders. And then this, in the court's view, the evidence at issue in the present case, namely drugs hidden in the applicant's body which were obtained by the forcible administration of emetics, could be considered to fall into the category of material having an existence independent of the will of the suspect, the use of which is generally not prohibited in criminal proceedings. However, there are several elements which distinguish the present case from the examples listed in Saunders. First, as with the impugned measures in the Funke and JB in Switzerland cases, the administration of emetics was used to retrieve real evidence in defiance of the applicant's will. Conversely, the bodily material listed in the Saunders case concerned material obtained by coercion for forensic examination with a view to detecting, for example, the presence of alcohol or drugs. Now, my Lord, again, it's not particularly easy to understand.
Yes, I mean, the comparison of Funke with the use of emetics is curious.
The point
idea.
being, my Lord, is that there are only certain categories of coercion which are of a nature or degree which cross the threshold into being into privileged territory.
Categories of coercion.
Categories of coercion. Now, one category of coercion is the cruel trilemma. Another one is applying a use of force which engages Article 3, like in Jallow. On the other hand, a category of coercion that does not cross the threshold is that was used in Murray, for example. Another category that is not sufficient to cross the threshold.
What's the underlying principle?
For privilege.
It's just a question of the degree, the extent to which one is repelled by the method used.
It is down to the nature and degree of coercion that was used.
I think that point is made in the next paragraph, paragraph 114.
Secondly, the degree of force used in the present case differs significantly from the degree of compulsion normally required to obtain the types of material referred to in the Saunders case. Exactly.
Paragraph 117 is really the key, I think. It lists the factors which the court will have regard.
Yes, my Lord, that's
And the interesting thing about this is that I think it could be said to demonstrate an evolution in the court's jurisprudence, that it's no longer saying, well, it might have been understood as saying in some of the earlier cases that there was effectively an absolute principle that no one could be compelled to incriminate himself, whereas the implication of paragraph 117 is that there is a balancing exercise involved.
my Lord, I accept that it is a balancing exercise. And I accept that there's a balancing exercise which must address the question of whether the very essence of the privilege has been destroyed. And in deciding that question, the factors that are relevant include the nature and degree of compulsion, but it also includes the weight of the public interest in the investigation and punishment of the offence at issue, and the existence of any relevant safeguards in the procedure, and the use to which any material is put. Now, what we say is that there are now many authorities which have made it clear as a pikestaff that the nature of the compulsion that is involved in applying, by compelling somebody to answer questions under pain of criminal sanction, is of a nature or degree that crosses the threshold. And it's only been in very exceptional circumstances where the court has found there's no breach of Article 6 as a result, and that is in cases like O'Halloran. And I'm about to take you to O'Halloran, and I should be able to do that before we finish today.
But is this, in Jallow, is this the sort of best Grand Chamber summary of the principles we have?
I think the best Grand Chamber, because I've got to take you to O'Halloran, and then I've got to take you to paragraph 267 of Ibrahim, which is the most recent Grand Chamber decision, where there is, it's in my case, you would have read it already, where the court draws these strands together.
Do we not need to look at paragraph 121, where the court specifically takes into account that the evidence was such that the conviction could not have been obtained without use of the material, and that there was no discretion in the national court to exclude the evidence.
Yes, but the point is that you can have a breach of the privilege under Article 6, even if there isn't a subsequent criminal prosecution. If it's been obtained for the purposes of a criminal investigation, then the very act of obtaining it is the breach. And so
But we have to hypothesize the criminal prosecution here, don't we?
there has to be the risk of a prosecution at the time at which the demand is made.
Right.
But if there is subsequently no criminal trial, that doesn't mean that there's not been a breach, because there are 2 points at which the breach can occur. One is at the point at which the evidence is deployed at trial, but the other is when the demand is made and the individual is placed in the cruel trilemma. So both stages there can be a breach, and cases like Shannon make it clear that you don't actually have to have a subsequent criminal trial for the initial demand to have been a breach of the privilege. So, my lady, while you're quite right that it is a relevant consideration, it is not a necessary factor in order for there to be a breach. And my submission is that in all the cases that the court looks at, the court has considered, the only cases where compulsion of the nature or degree that we are involved with in this case, that is to say, a compulsory demand for information or documents, has always been found to be a breach of Article 6.
But one can understand that in this case, it's crucial that there was this intrusive interference with the bodily integrity of the defendant. But in a case in which there is not, why shouldn't the same principle, namely what you call use immunity, not be relevant to the pre-trial potential violation as it is to the trial?
My lady, of course, there has to be an intention on the part of the investigator at the point at which they make the demand to obtain information for the purposes of a criminal investigation. So what engages the privilege at the pre-trial stage is that the investigator is using the cruel trilemma to coerce somebody to provide evidence which is relevant to the investigation that they're conducting.
But my question moved on from there. On that assumption, why shouldn't the fact that the National Court has a discretion to exclude the evidence not be relevant to the interference at the pre-trial stage as it is to the trial stage?
Because a discretion is not enough of a safeguard. There needs to be a guaranteed use immunity. So, my lady, my lords, the next case is O'Halloran,
Thank you.
which is at volume 8, tab 85, at 4398. Now, again, this is a speeding case, and it's important to recognise that this is a case which followed on from the Privy Council's decision in Brown and Stott. And in Brown and Stott, the Privy Council held that to compel the driver of a car, or the owner of a car, to say who was driving the car for the purposes of investigation of a driving offence, and the subsequent use of the answer did not breach the privilege. And it did not breach the privilege for reasons which the Privy Council held to include the fact that there was a very minor, it was only for a single piece of information, and it was conducted in the context of a regulatory regime where anybody who chose to drive accepted implicitly that there were regulatory requirements upon them, which would include a requirement to admit that they were the driver. And in the Grand Chamber decision in O'Halloran, the Strasbourg Court effectively followed the approach taken in Brown and Stott. If I can take you to paragraphs 53, which is at page, just bear with me. (402). So what the applicants in that case were arguing was that the privilege against self-incrimination was was effectively absolute. So that once a compulsory demand had been made that crossed the necessary threshold for the privilege to be engaged, then it was essentially an open and shut case. There was a violation. And the court said this in relation to that submission, 5 lines down, paragraph 53. It is true, as pointed out by the applicants, that in all the cases to date in which direct compulsion was applied to require an actual or potential suspect to provide information which contributed or might have contributed to his conviction, the court has found a violation of the applicant's privilege against self-incrimination. So that's where I get that proposition from. It does not, however, follow that any direct compulsion will automatically result in a violation. While the right to a fair trial under Article 6 is an unqualified right, what constitutes a fair trial cannot be the subject of a single unvarying rule, but must depend on the circumstances of the particular case. This was confirmed in the specific context of the right to remain silent in the Heaney and Guinness, and more recently the Jallow judgment, in which the court identified the factors which it would have regard in determining whether the privilege had been violated. The applicants maintained that the Jallow case was distinguishable from the present, in that it concerned not the obtaining by compulsion of incriminatory statements, but rather the use of real evidence of the kind indicated in the Saunders judgment, such as breath, blood, and urine samples, and thus was an exception to the general rule laid down in that judgment. The court accepts that the factual circumstances of Jallow were very different from the present case. It's nevertheless unpersuaded by the applicant's argument. Just pausing there for a moment, what the submission was that the Jallow case involved Saunders category paragraph 69, not Saunders category paragraph 68. That's to say what they call what's in other contexts being called the real evidence exception, but it's the paragraph 69 exception. The court is nevertheless unpersuaded by the applicant's argument, even if a clear distinction could be drawn in every case between the use of compulsion to obtain incriminatory statements on the one hand and real evidence of an incriminatory on the other, i.e. between the paragraph 68 and paragraph 69 of Saunders. The court observes that the Jallow case was not treated as one falling within the real evidence exception in the Saunders judgment, i.e. it was not held to fall within paragraph 69. On the contrary, the court held that the case was to be treated as one of self-incrimination, according to the broader meaning given to that term in the cases of Funke and JB, to encompass cases in which coercion to hand over incriminating evidence was an issue, i.e. it was not a Saunders paragraph 69 case, it was a Saunders paragraph 68 case, like Funke, like JB. In the light of the principles contained in its Jallow judgment, and in order to determine whether the essence of the applicant's right to remain silent and privilege against self-incrimination was infringed, the court will focus on the nature and degree of compulsion used to obtain the evidence, the existence of any relevant safeguards in the procedure, and the use to which any material so obtained was put. As to the nature and degree of compulsion, it was accepted that the penalty for failure to comply was a fine of up to £1,000. Paragraph 57, the court accepted that the compulsion was of a direct nature. However, and having cited Lord Bingham's speech in Brown and Stott, the last paragraph, those who choose to keep and drive motor cars can be taken to have accepted certain responsibilities and obligations as part of the regulatory regime related to motor vehicles. And in the legal framework of the UK, these responsibilities include the obligation in the event of suspected commission of road traffic offences to inform the authorities of the identity of the driver on that occasion. And then this, paragraph 58, a further aspect of the compulsion applied in the present case is the limited nature of the inquiry. And then paragraph 59, the court in the case of Jallow referred to the existence of relevant safeguards in the procedure, and the court then referred to the safeguards that were available in a criminal trial and the risk of unreliable admissions being negligible. Then as to the use to which the statements were put, it was accepted that it was used in evidence against him. But at the bottom of the page, 2 sentences from the bottom, again, as noted in the case of Brown and Stott, the identity of the driver is only one element in the offence of speeding. There is no question of a conviction arising in the underlying proceedings in respect solely of the information obtained as a result of Section 172. As Mr. Francis refused to make a statement, it could not be used in the underlying proceedings, and indeed the underlying proceedings were never pursued. The question of the use of statements in criminal proceedings did not arise, as his refusal to make a statement was not used as evidence. it constituted the offence itself. Having regard to all the circumstances of the case, including the special nature of the regulatory regime at issue and the limited nature of the information sought, the Court considers that the essence of the applicant's right to remain silent and their privilege against self-incrimination has not been destroyed. Now, my lady, my lords, I see the time, but if I just summarise the point that I wish to draw from this in 30 seconds.
Well, it may take more than 30 seconds. There may be some questions about the extent to which the principle about effectively subjecting yourself to a regime by virtue of your own activities might be carried over into the context of a provider of financial services.
Well,
I think probably we had better pursue this after the short adjournment, Ms. Byrne.
Thank you, my lord.
Thank you.